So what do you mean by discharge? A negotiable instrument is said to be discharged when all the rights of action under it are completely extinguished and it ceased to be negotiable. All the rights of actions are considered to be completely extinguished only when all the parties liable on the instrument are discharged of their liabilities. Thus, a negotiable instrument is discharged if the acceptor has become the holder of the instrument at or after maturity in his own rights. That is, not in any other capacity such as agent, executor, trustee. For instance, A accepts a bill drawn on him by B. So, what do you mean by discharge of negotiable instrument? Where the person cannot able to proceed the payment or where he cannot able to withdraw the amount. In terms of lot of reasons, let's discuss one by one. Mode of discharge of liability in negotiable instrument. Under the following modes, the maker or acceptor and endorser of a negotiable instrument is discharged from liability. First, number one, by cancellation. Under this scheme, a holder who cancel acceptors or endorsers name apparently or with the intention to discharge him from the negotiable instrument, the latter is said to have discharged. For example, I have given check to one person. Before he is going to withdraw money from the banker, I can cancel this transaction. I can instruct the banker that don't release the payment to the so and so person. That is called cancellation. Even I can give an instruction to the banker, don't allow him to do endorsement of my check. If someone bring the check, those who have the position cannot able to withdraw the money. Why? Because I have given instruction to the banker not to withdraw the money. By release, a holder thereof who by means other than the cancellation discharges maker, acceptor or endorser to all the parties delivering a title under such holder after notice of such discharge. So usually what you may discharge in what are the way the particular contract comes to end. Breach is different, discharge is different. Breach in the sense, if the person committed to the contract, suddenly they are not willing to proceed further, that is called breach, break in a contract. Discharge means in what are all the situation the particular contract is coming to end. So similarly, in the discharge of negotiable instrument, it means that in what are all the way the rules, the particular person's rights and obligation is coming to end. So by release in the sense, once I given a check, if the person delivered and withdraw the money, automatically the transaction between the person will comes to end. By payment into the due course, when the payment on instrument, its maturity is made by the party liable, then all the parties stand discharged from the liability of the negotiable instrument. By allowing drawee, in this case, if a person holding the negotiable instrument allows the drawee for over 48 hours to consider whether he will accept the same, then all the previous who did not consent to said allowance stand discharged. So the person whose name has been mentioned in the check, he or she is not accepted the check within a 48 hours, then it can be discharged. Next one is material alteration. In case in a material alteration brought into the instrument, all the parties who do not consent to said alteration stand discharged from the liability. For example, I issued the check to concerned person. When he hand over the check to the banker to withdraw the money, if the banker finds any kind of material alteration in the check, if he or she is not satisfied, then they will be conforming with the account holder. If the account holder has not given any kind of a consent regarding the material alteration, then the person who carries the check, he cannot able to withdraw the money. Then it can be discharged. Notice of dishonor. In case the holder of negotiable instrument fails to issue notice of dishonor to all the previous parties, they stand discharged. For example, I have given a check to one person. When he unable to withdraw the money, maybe due to low balance or something else, he should inform to the concerned account holder. If he or she fails to do so, then it can be discharged. By operation of law, liability against the negotiable instrument also stand discharged in case of legal operations like insolvency of the debtor, loss of remedy on expiry of the limitation, merger of the note into the judgment debt, merger of lesser security into the higher security. For example, I have given check to one person. As we know well, the check validity period is 6 months. So after 5 month later, if the person who is having the possession of the check, if he or she willing to withdraw the money, at the time when he take the check to the banker, that time the person, the account holder who issued the check is not live, no more. Then he cannot able to proceed the check because there will not be any kind of a sufficient amount also in the particular account. Dishonor of negotiable instrument. A bill may be dishonored by non-acceptance or by non-payment. A promissory note and a check are dishonored for a non-payment only. When a negotiable instrument is dishonored, then the holder of the instrument must give notice to all the prior parties to make them liable for dishonor. When he fails, then he forfeit his rights. Dishonor by non-acceptance. A bill of exchange is dishonored in any one of the following ways. If the drawee does not accept the bill within 48 hours from the time of presentation through its duly presented for acceptance. For example, the person who received the check, he is trying to deposit the check into the banker, but the banker is refusing to accept the check within a 48 hours due to maybe some reasons, then it can be discharged. If there are several drawees and all of them don't accept, when a presentation for acceptance is excused and the bill is not accepted, that means the account holder might have given some instruction to the banker not to release the payment to the concerned person who is carrying the check. When the drawee is a factitious person, the bill is not accepted. When the drawer is incompetent to a contract, for example, I have given a check to so and so person, but the person who carries the check is not up to the age limit according to the Contract Act. Or I have given check to one client, but the client endorsed the check to one person who is not up to the qualification of age limit. If he or she carries the check, he cannot able to withdraw the cash. Then it will be called as a discharge of contract. When the drawees give a qualified conditional acceptance, for example, as we discussed types of crossing, in the check I have mentioned that account payee only, but the person who carries the check, he would like to get a cash from the banker, then banker cannot able to accept it. Why? Because in the check, in the left side corner, in the two parallel line, it has been clearly mentioned account payee only. It is called as a special crossing, right? So where if this kind of instruction is given by the holder, account holder to the banker, he cannot able to violate it. The banker should follow the same instructions what is provided by the account holder. So in these are the way the discharge can happen by non-acceptance. Dishonor by non-payment. A promissory note, bill of exchange, check is said to be dishonored by the drawers makes default in payment which has to be duly made. Notice of dishonor. When the instrument is dishonored, then the holder of an instrument must give proper notice to the prior parties to make them liable, otherwise he forfeit his rights. Dishonor of negotiable instrument can be done in the following way, like by payment in due course, by parties primarily liable becoming a holder, by express waiver, by cancellation, by discharge as a simple contract. So let's discuss one case study here. By means of fall preference, A has obtained from B a check crossed not negotiable. He took that check to the banker other than the drawee bank, which paid it. B sues the bank for conversion. Now, let us answer for these questions. Has A committed any offense or irregularity under the Negotiable Instrument Act? Is B entitled to get any relief? How will you decide this case? The judgment is, here the check is crossed with a label called negotiable instrument, that is special crossing, which means that transferee cannot get a better title than that of transfer of. It also means that it can be paid only to a certain person who carries the check. A negotiable instrument is one which is made payable to the bearer, who is called bearer, the person who carries the check. That is to anyone who holds it. Here, because of fall preference, A has obtained a check. Because of that, not negotiable cross check gives authority to receive the payment of a check. Therefore, A followed the rules and regulations covered under the Negotiable Instrument Act. Hence, A did not committed any offense or irregularity under the negotiable instrument. Here, because of fall preference, A obtained a check from B with a cross check, not negotiable. Because of this crossing, the check become made available to the bearer to pay anyone who holds it. Hence, here B will not get any relief as the transaction is lawful under the Negotiable Instrument Act 1881.